नमस्ते फ्रेंड्स, आप सभी का एक बार फिर से स्वागत। फ्रेंड्स, MC सिंगला बैंक पेंशन अपडेशन केस 20 मार्च 25 को सुप्रीम कोर्ट में हियरिंग के लिए फिक्स्ड है और इसी संबंध में एक मैसेज DS मूर्ति साहब के पेंशन एक्टिविस्ट हैं उनके द्वारा MC सिंगला केस ऑन अपडेशन ऑफ पेंशन coming up for hearing in Supreme Court on 20th March 25. If the petitioner association can get a definite response from the IBA, Government of India, to the following 13 questions in the court during the hearing, it is certain that the case will be decided fast and of course in our favor. वो 13 questions क्या हैं? First, why updation of pension is not offered to public sector bank pensioners for the last 3 decades, while in every other sector updation of pension is ensured along with every wage revision to the respective employees. Second, why the legally binding obligation in the MOS dated 29th October 93 under Section 2P and Section 18(1) of the ID Act 1947 and Rules 58 of the ID Central Rules 1957, including DA at par with RBI pensioners and updation of pension on RBI lines have not been complied with, especially when the Apex Court have been repeatedly affirming through various judgments the following, like the right under contract cannot be taken away and they become enforceable by a court of law. Its binding effect cannot be changed on the basis of what parties choose to say afterwards, nor them can be permitted to wriggle out. The contract is required to be read as a whole. Case number 246/2015 dated 2nd March 20. Assistant General Manager SBI and others versus Radhey Shyam Pandey, 3-judge bench. The true construction of a contract must depend upon the import of words used and not upon what the party choose to say afterwards. Nor does subsequent conduct of the parties in the performance of the contract affect the true effect of the clear and the unambiguous words used in contract. The nature and purpose of the contract is an important guide in ascertaining the intention of the parties. Bank of India and others versus K Mohandas and others 2009. Third point है, while the MOS dated 29th October 93 and Pension Regulation 95 are to be read together and made applicable accordingly, since they are equally binding on all parties and enforceable under the law. Why no worthwhile attempt has not been made in that direction so far? The validity of the MOS dated 29th October 93 all these years cannot be doubted, especially when the DFS and Government of India had taken it as the basis for extending pensionary benefits to employees of regional rural banks as per the farmer's affidavit filed in the Apex Court in that connection, and the court had accepted it. Fourth, when the Apex Court through various judgments including Devkinandan Prasad versus the State of Bihar, DS Nakara and others versus Union of India, State of Rajasthan versus Mahendranath Sharma, etc. have affirmed that pension is a deferred wages and must be updated along with every wages revision for serving employee, why no steps have been taken by IBA, DFS in this regard so far. Fifth point है, when the Parliamentary Committee on Subordinate Legislation Lok Sabha in the year 2017 recommended pension updation for RBI employees, but it was denied by the Ministry of Finance, citing the reason that in case it was done for RBI employees, then similar demand would be raised by PSB retirees. Then why updation is denied now to PSB retirees while the same is already extended to RBI retirees? 6 point. What was the intention of amending the Rule 35(1) of pension regulation as obtaining now by clearly substituting the words will be with shall be and adding wherever applicable for updation of pension, if not for making it applicable for all pensioners uniformly? Otherwise, what is the extra improvement made through this amendment? 7th, when there is the word updation in the Rule 35(1) of the pension regulations, how can IBA declare in its affidavit filed in SC that there is no provision for updation in the pension regulations? Is it not perjury inviting contempt of court? And how to IBA explain the reference to Rule 35(1) of pension regulations by the Apex Court in case 5525/2012 dated 13 February 18, Bank of Baroda versus G. Palani, wide para 9 of the judgment, especially when the court says the same is extracted from the pension regulations. 8 point. When various petitioners quote the pension fund position of various banks as more than sufficient to meet the increasing cost of updation based on the respective accounts statements, how do IBA respond to their arguments in this regard? 9th, when the Apex Court in a few judgments have already affirmed that lack of funds cannot be a reason for not extending the pensionary benefits to the retirees, since once the employer implements the pension scheme in an organization, it is for that employer to find adequate resources to meet the consequential future requirements in this regard. How IBA DFS can argue lack of funds for denying updation of pension? In their recent judgment in Punjab State Cooperative Agriculture Development Bank Limited versus Restart Cooperative Societies and others, dated judgment 11th December 22, affirmed that, in our view, non-availability of financial resources would not be a defense available to the applicant bank in taking away the vested rights accrued to the employees, that too when it is for their socio-economic security. It is an assurance that in their old age their periodical payment towards pension shall remain assured. The pension which is being paid to them is not a bounty, and it is for the appellant to divert the resources from where the funds can be made available to fulfill the rights of the employees in protecting the vested interests accrued in their favor. The court further observed, White Para 54 of the judgment, that the rule-making authority was presumed to know repercussions of the particular piece of subordinate legislation, and once the bank took a cautious decision after the taking permission from the government introduced the pension scheme, it can be presumed that the competent authority was aware of the resources from where the funds are to be created for making payment to the retirees. Similar affirmations have been already made by the Honorable Supreme Court in judgments such as Kapila Hingorani versus the State of Bihar 2003, Ratlam Municipality versus Bardi Chand 1980, and other cases, BL Barda versus Union of India in 1996. 10th point. When the Apex Court has clearly affirmed in various judgments that in case of any dispute over a particular clause, section of a particular statute, that interpretation should be in favor of the employees. Example, the judgment in the state of Rajasthan and others versus O.P. Gupta. 16734 2022 dated 19 September 22, the court, White Para 28 of the judgment, observed that it is settled law that when financial rules framed by the government such assure pension rule are capable of more than one, the court show lean towards that interpretation which goes in the favor of the employees. Then how can IBA misinterpreted twist rule number 35(1) of the pension regulations against the employees' pensioners. 11th, when the Honorable Supreme Court had time and again affirmed and reaffirmed that there cannot be a class within the homogeneous class of pensioners and there cannot be any sort of discrimination between different segments of the same homogeneous class by arbitrarily fixing a date, how can IBA fix different formula for basic pension as well as DA pattern? Example, Apex Court judgment in Colonel B.J. Akara, retired versus Government of India in 2006. Alleging Section 709, date of judgment 10 October 2006, White Para 20 says that commutation of pension cannot be different formula, thereby applying unequal treatment on the ground that some retired earlier and some retired later. 12th, when the Apex Court had affirmed that irrespective of the date of retirement, a pensioner should receive a basic pension based on at least equivalent to 50% of the corresponding basic pay in the running pay scale for serving employee in relation to the basic pay of the pensioner at the time of retirement, how can IBA ignore the binding verdict of the Apex Court SC judgment in State of Rajasthan versus Mahendranath Sharma, dated judgment 1st July 2050. 13. IBA had earlier written to Sri R.N. Gadbole on pension scheme, letter dated 17 December 93, that inter alia that, as you are aware, that scheme has been introduced on the lines on the pension scheme available to the central government employees and employees of the Reserve Bank of India. And again, white letter dated 16 March 94, addressed to Sri R.N. Gadbole, inter alia informed, in view of the fact that the entire scheme is patterned on the lines of Reserve Bank of India dearness formula, the pension regulation will be as per the provisions in the Reserve Bank of India pension regulations. That being the earlier stand of IBA, then why IBA subsequently made an bold face and reserved their stand. Thank you friends. Namaste.